Hello, everyone. Welcome to Save News TV. And I am your host, AZ Hubbard. So today we're going to cover the TD Jakes versus Duane Youngblood case. And we're still in the midst of the sanction portion of Tyrone Blackburn. So, as you know, we don't have a dog in this fight over here. And if you're team Jakes or if you're team Blackburn or team Youngblood, just keep it real. So what has happened is that Jake's team gave Youngblood attorney a discount on the fees. All right, we're going to go over that. But what I am going to say is, it's getting to the point now that this is taking the lead of this case. It's time for this to be finished. Okay, so we can move forward in the case. We did not sign up for the Tyrone Blackburn portion of it, but it is exciting, and let's get into it. And just also, like I said, he requested a discount. He got a discount. Well, he didn't request a discount yet. They gave him a discount, and also we got the rebuttal from young I mean Blackburn regarding the fees that TD Jake's team want to recover for the AI filings of these cases. So let's get into it, everybody. Let's get into it. Okay, first, this is from TD Jakes' attorney, and the exercising of billing judgments. So they amended, what they're doing is amending the amount that they requested in the proposed fees set. If you go back to the last video, we cleared up facts that, other people were reporting that the judge had ruled on it. No, the judge hasn't ruled on it. The TD Jakes' attorney just proposed a motion for fees, and Tyrone Blackburn had a certain number of days to reply to the fees, and we're going to go over that next after we finish this. And then now we await for the judge, but let's go over this now. Okay, exercise in billing judgment. And they continue. If based solely on the foregoing criteria, we should seek $67,004.69 in attorney's fees for the opposition, $18,906 in attorney's fees for the surreply, and $219 in reimbursements for the hearing transcript, for a total of $86,129.94 from my firm alone. Notice what it said, my firm alone. So that means that there are other firms attached, but they're only seeking the fees from their firm, which is interesting. Okay, so also he goes on to say, however, in the billing judgment, I have discounted some of the fees, some of these time entries to control a large number of billing hours. I also exercised my billing judgment when I provided Bishop Jakes with a 5% across the board discount for May of 2025. Attached is Exhibit C are tables showing the invoice entries from MWPP with each line item discounted. I also exercise billing judgment to limit the hours sought at all. If an entry either A, commingled time spent on the opposition or surply with other substantially unrelated tasks, or B, would reveal confidential strategic information, we have not sought reimbursement. So evidently, like I said, this is a roadblock. This Tyrone Blackburn situation is a roadblock in the TD Jakes versus Duane Youngblood case. But one thing about it is that they still did the work. They put in the time. And what they're not doing is, they're not trying to overbill. They pulled back some of the fees, they gave a discount, and they also removed the billable hours that commingled, and they removed the billable hours that would expose their strategy as they go forward in the Dwayne Youngblood versus TD Jakes versus Youngblood case. Remember, there are 10 unnamed John Doe co-defendants in this case. So they can't disclose all of their strategy. So they chose not to bill Blackburn for, what they call AI hallucination filings. So it goes on to say the total fees sought after the foregoing calculations and adjustments for MWPP work. Plaintiff seeks $57,360.94 in attorney fees for the opposition, $14,039.69 in attorney fees for the reply, and $219 in reimbursement for the hearing transcript, for a total of $71,463. So now it has gone down from $76,000. Like I said in our last video, it was a proposed fee, like, judgment fee that they requested. Even though people were reporting that the judge approved it, but it was a proposed fee. And this right here is also proposed because the judge has not ruled on this case or amount as regarding sanctions against Tyrone Blackburn. So now it is $71,400.63. Having litigated defamation cases on a national renowned and having supervised the work of other attorneys for many years, I believe MWPP's rates and hours charged in this course of this case are reasonably within the range of the rates of attorneys with comparable experience and expertise, and are appropriate given the task assigned and the scope of the duration of this matter. I declare under penalty of perjury that the foregoing is true and the correct. Dustin A. Pulse. So, these are heavy hitters, attorneys. That's why we made our estimate on how much this could possibly end up costing. We started from our estimate from 50,000 up to 100,000, and then when they put this in, depending on the fees and everything that the judge might impose from the court side, we could estimate it to be anywhere between 100 and 150,000. We don't know. This is just our guesstimate. So far, Saveites, we've been on track. We've been on point with our guesstimate and estimate of these fees. So now we're going to get into um, Blackburn's reply as he throws himself on the mercy of the court. But one thing about it, let's just get into it and you can tell for yourself. Okay. So this is Blackburn's reply. Like I said earlier, hopefully the judge will go on and rule on this case swiftly. And let's get into this. We are not reading all these pages. And because see, this is the thing. And I'm sure other content creators that's covering this case can agree with me on. This is just too many files of paper unnecessarily. This thing is 324 pages. 48 pages. No, we're not reading all this. We're not even going to read a tenth of this. It is ridiculous. Just answer the questions, do what the judge asked, and be done with it. Like I said, we don't have a dog in this fight, but personally, I am sick of um this portion of the case because it was totally unnecessary. for him to do what he did. But anyway, let's let's get into this. And one thing about it, I just personally don't think that TD Jakes is going to back down, nor should he. Regardless, you might can have sympathy for Tyrone Blackburn, but he calls these fees. And TD Jakes, out of all fairness, like I said, we don't have a dog in the fight, but in all fairness, he should not have to bear the burden of this cost. But anyway, let's see what Tyrone Blackburn says as far as him falling on the sword and on the mercy of the court. Okay, so plaintiff statement. The plaintiff's demand for $76,197.63 in attorney's fees is excessive, unsupported by governing law, and inconsistent with the court's discretion under Rule 11. Okay, stop right there. So this tell you now, this was filed on the 19th. He had 7 days from the 8th to reply, and he's still late, with his reply on this. So, you know, the I don't see where he filed for requesting an extension, but he's still late on his request, response to this. If he would have looked back and looked up the court documents like I did and other content creators did, you would see that this amount has been amended. Right now, what I am seeing, my personal opinion, I'm not an attorney. I'm not trying to sway anybody's opinion. This is just me. I feel like this is sloppy work that Blackburn is doing, you know. And again, we don't have a dog in this fight, but it's not. I just don't feel like it's TD Jakes' responsibility to have to pay for Tyrone Blackburn's sloppy work. But let's get into it. He says, I did not challenge that mistakes occurred in the second motion to dismiss. I also explained to the courts during the show cause hearing, I came from a military family. My dad is a Marine. My uncles are Marines. And now my nephew is a Marine. Serve to Service to the least of these and unequivocal accountability when wrong is how I was raised and all that I know. Okay. Yeah, I mean, see again, this has nothing to do with nothing. That's why it's 319 pages. That's like somebody saying, my parents I was raised in a Christian household. My parents are Christian. That doesn't get you into heaven. That's their works. That's their deeds. But let's go on because I want to get through this and I want the judge to rule swiftly, and I want us to move on back to the case and see what's going on between the main case that caused this is okay. I have taken full ownership of those citation errors as explained to the court at the show cause hearing. However, plaintiff fees petition overlooks the factual record, the remedial efforts that are underway prior to my involuntary termination, and the legal norms applied by courts in similar situations, AI related citation error cases. Two, I was terminated mid correction, preventing completion of remedial steps. As I explained under oath during the show cause hearing, I began correcting the citation errors immediately upon receipt of Rule 11, Safe Harbor Letter. I was in the middle of preparing the errata. I plan to substitute the relevant pages of the second motion to dismiss with corrected citations when my client terminated me on June 23rd, 2025. This unexpected termination stripped me of the ability to complete the remedial process and to file corrections with the court under Rule 11C2. The suggestion that no steps were taken is demonstrably false. I took full responsibility at the hearing without excuse or deflection. At no point did I minimize or shift blame. I apologized to the court and counsel for the defendants, and I candidly acknowledged the errors in open court. Yes, he did. All well and good. But when you're talking about a bill for over $70,000 because of your error and you expect someone else to eat that? Do you I mean, I need you all in the comment section. Do you all feel that it is fair and right for TD Jakes to pay that $70,000 plus to his attorneys because of Tyrone Blackburn's AI hallucinations? Yeah, I mean, really, regardless of what side you're on, I mean, fair is fair. I personally do not feel that this is TD Jake's responsibility to eat this cost. Okay. But you all tell me in the comment section. Okay. Um, Where did I leave off? Okay, I explained that I had recently activated new subscription to LexisNexis and Westlaw, both of which had integrated emerging AI functions that I was unfamiliar with. While the technology contributed to the citation issues, I accept that it was my responsibility, not the tools, to verify every case after submission. Correct, 100%, because irrespective of how many errors that machine made, that software made, at the end of the day, it is Blackburn's responsibility. Just like if he had a paralegal that made errors, if he signed, he still have to, excuse me, he still has to verify before he signs under penalty of perjury, and filing a motion or whatever, that is his name on the line, not LexisNexis, not Westlaw, not a paralegal or anybody else. That is him. So, that's why I wanted to move on with this case, y'all. I know, it's very rare you all see me get to the point of I'm done with this, but I'm really done with this portion of the case, and I want the judge to rule, but it might take a few days. We will see. He says, my mistake was not fully auditing each citation before filing. That is on me. I made no excuses then. I make no excuses now. I have taken substantial corrective steps since the filing. Since the events at issue, I have completed more than 11 hours of CLE course focused on the artificial intelligence, ethics, data protection, and small firm compliance. These courses, spanning both in New York and New Jersey CLE accredited systems, reflect my genuine effort to deepen my understanding of emerging risks and best practices surrounding AI in the legal profession. True and correct copies of my CLE certifications are attached to Exhibit A. He goes, put this in here. But as you notice, if you look at the dates he took this, some of these were not taken until after the show cause, hearing. Look at the dates, everybody. He started in July 18th and all the way through to August 8th. His 11 hours and 0.75. These are things, I understand. I feel for him, but hey, I wouldn't want to foot a 70,000 plus bill because of somebody else's mistake. As a matter of fact, let me be totally 100% accurate. A $71,400.63 bill because somebody else made a mistake. No, you pay your own bill. It was your mistake and you need to pay it. And that's just my personal opinion. Okay. Even though, he'll be referencing the 76,000, but now is $71,400.63. Okay. So he goes on to say, I'm a solo practitioner. Approximately 60% of my cases is handled On a pro bono basis, my representation of Mr. Youngblood was entirely pro bono. I do not possess the resources to pay $76,197.63 or any amount without jeopardizing my practice and my clients, most of whom are indigent or survivors of SA. As discussed below, across the country, judges have opted for education and caution over punishment. Okay, but again, somebody's got to pay those attorney fees. Those attorneys should not absorb the cost, and TD Jakes shouldn't absorb the cost. This is your mistake. Even if the judge orders you to, um, maybe do work within their law firm or whatever, you've got to pay off this bill, dude. This is your bill. You got to pay it. Okay. Okay. Requests for alternative sanctions, CLE, not financial penalties. If the court is inclined to issue any sanctions, I respectfully request that it consider non-financial remedy such as mandatory CLEs and public admonition that would mirror what numerous judges, including those in this very district, have done in response to comparable incidents. For instance, in Hill, in versus Hill, the court this court issued a public reprimand where the attorney lied to the court and showed no remorse, concluding that public admonition, not financial sanctions, was appropriate. Even under the highly evidentiary standards, the court in Hill rightfully recognized that honesty is a matter of character, not something curable through CLEs or fines. Here, unlike Hill, I acknowledge the error immediately and have demonstrated remorse and corrective action. One thing, I haven't read the Hill case, but I do believe that the difference is, the attorney lied to the court, but I don't, it doesn't. He did not cause fees outside of that court. The difference in these two cases, and I'm thinking that the judge will make mention of this, is that there's a third party that's being injured by his actions, and that is TD Jakes. There's another party being injured, and that's TD Jakes. And I just can't see, and I could be mistaken. You all get in the comments and tell me. I cannot see the judge ignoring the injury, the financial injury, the monetary injury that would be caused to TD Jakes if he does not enact monetary fines. This should not and give TD Jakes everything monetary that they're asking for. I just can't see this happening. But again, there's a lot of things I miss, could be wrong. Y'all tell me your opinion. I accept responsibility and I have shown in good faith, but the 76,000 sanctions, $1,000 sanctions for citation, never intended to mislead, would have been punitive, not corrective. Across Courts across the country have addressed AI related citation errors in a measured and proportionate manner. In Hall versus the Academy Charter School, the court declined to impose monetary sanctions despite the submission of fabricated case law. The court accepted counsel's explanation that the error stemmed from AI assisted drafting and accepted counsel's apology that the submission was not done in bad faith. Similar in Robbins versus Martin, the court issued only a warning to counsel for AI citation errors and declined to issue monetary sanctions. In Mavi versus Commissioners of SSA, the court likewise declined to impose any financial penalty for AI generated citations. Instead, the judge acknowledged the widespread learning curve surrounding the AI tools and opted for public admonition. In the matter of Johnson versus Dunn, the court declined to award fees and ordered only corrective education. These cases reflect a growing recognition that honest, non malicious errors in the use of AI tools warrant education and reform, not financial ruin. This approach better supports the long term integrity of the legal system, especially when here the attorney promptly acknowledged the mistakes, took steps to prevent recurrence, and acted without bad faith. Well, one thing about it, I feel, again, this is my opinion, everybody's entitled to their opinion, but I feel that if the judge does set a precedent for enacting fees, this will stop people, these attorneys, from using AI or be more cautious with submitting AI motions without double checking everything. As long as these attorneys get a slap on the wrist, they will not change their behavior. And this is not just Blackburn, this is all of the attorneys that do these cases. I feel that there should be stiffer punishments. And the judges also, because some of the judges have been caught using AI, but there should be stiffer penalties. And with these stiffer penalties, they will realize, hey, I don't want to lose financial or possible ruin of my career, not to mention other sanctions that could be imposed if I rely on AI. They will become more cognizant and more diligent in doing their work and making sure and verifying that everything in the what they file to the courts are true and accurate. But again, as long as you keep giving them a slap on the wrist, they're not going to do any better than what they're doing now. So, and I think this should be a test case, and moving forward, that should set the stage and example for different attorneys using AI, and this will just nip it in the bud. Okay. So it goes on to say, notice to the court regarding the extrajudicial conduct by plaintiff's counsel. I respectfully place the court on notice of extrajudicial conduct undertaken by plaintiff's counsel Dustin Pulsh, which has caused me significant personal and professional harm. On or about June the 11th, 2025, Mr. Polch filed an ethics complaint against me with the New Jersey State Bar. And based on the nature of his allegations, I reasonably presumed he filed similar complaints with the New York State Bar and potentially others. These complaints falsely accused me of misrepresenting my admission to the District of Columbia Bar. Rather than extending the professional courtesy of a phone call or email, Mr. Poach chose to expend time and presumably his client's money contacting every state and federal licensing body to confirm my bar admission. His grievance, see Exhibit C, states that because he was not immediately provided confirmation of my DC bar admission, he proceeded to report me to multiple disciplinary authorities. Oh, wow. This is a gross overreach and, in my view, an abusive use of the grievance process. Okay, wow. He ain't play no games. He ain't play no games with him. He reported him everywhere. Let's get my Jamaica tea. Oh, yes. I love my Jamaica tea, everybody. Because all this reading, I get thirsty. Mm. Oh, yes. Okay. Ooh, that's good. As a result, I was plunged into unnecessary ethics inquiry by the New Jersey Office of Attorney Ethics and have been forced to retain an ethics attorney at my own expense despite my limited resources and pro bono centered practice. I now face the additional burden of preparing for possible follow up reviews from other jurisdictions despite having done nothing wrong. I tell you, TD Jakes' attorney is not playing out here. For the record, I am duly admitted to the District of Columbia Bar. I was officially sworn in on May 7th, 2024, by the Honorable Catherine H. Parker, United States Magistrate Judge for the District of New York. Any suggestions to the contrary is unequivocally false and could have been dispelled with a single phone call or email. Instead, plaintiff's counsel chose to escalate a good faith litigation dispute into an attempt to trigger professional ruin, weaponizing the ethics complaint process as a form of retaliation. In other words, what TD Jakes' attorney is trying to do is get them licensed. He's trying to snatch them licenses. Yes, that's what he's trying to do. Okay. This type of conduct exacerbates the punitive impact of already excessive fee demand and highlights the troubling lack of proportionately in the plaintiff's litigation strategy. In the context of Rule 11 dispute of a citation errors, I have publicly and fully owned this extrajudicial campaign is not only unjustified, but also corrosive to the integrity of the adversarial process. So, TD Jakes' attorneys is not playing. They tired of him, just like, just like some of us content creators are tired of him. This case should be about TD Jakes versus Duane Youngblood, but now it is about Tyrone Blackburn. He has hijacked this case to make it about him. He says he's doing it pro bono, and in doing it pro bono, he is now having to pay possibly for doing it pro bono. That's crazy. AI hallucinations have affected judges as well, inciting in the Third Circuit. The rise of generative artificial intelligence tools have has not only impacted attorneys, but has also led to citation errors in judicial opinions. In multiple instances, federal judges, including the Honorable Julian Xavier Niels of the District Court of New Jersey, have unknowingly incorporated hallucination cases and quotes into published orders, only to later withdraw those opinions after the errors were discovered. Now, as you all will remember, well, of course, like I said, yes, there has been judges that have been cited for this, but as you all recall from the last video and previous cases that we've covered, like I stated, these orders and motions, just like TD Jakes did a proposed motion for fees, that is written by the person that wants the motion. Generally, the judges do not write that. They just sign off on it if they agree. They also, make the necessary, ask them to do the necessary changes. But also, that still doesn't absolve the judge, even though the attorneys form the orders and the motions for the judge to sign the verdicts. It is still up to the person that's signing to verify that everything is correct. So we have to hold the judge at the same standard that we are holding Blackburn. For example, in CorMedix Securities litigation, Judge Niels withdrew a written opinion after it was revealed that the ruling included non existent case law and fabricated quotes. Excuse me. Similar, the Southern District of Mississippi, the Honorable Henry T. Wingate entered a temporary restraining order that included fictitious allegations and parties, a mistake that was later attributed to clerical oversight influenced by AI generated drafts. These incidents demonstrate that AI hallucinations are not a matter of willful generated drafts. These incidents demonstrate that AI hallucinations are not a matter of willful misconduct, but the emerging professional challenge affecting even the most experienced members of the bench. And that's why I say that if they start hardlining with fees, costs, and repercussions for using AI and not verifying the information, this will put this to a swift end. As long as these attorneys and judges get a slap on the wrist, they will not change their tactics. They will continue to rely on AI. They will continue to have erroneous rulings and motions and things of that nature. But as soon as you make them pay financially, you will see, or risk their law license, you will start seeing a change in this behavior. I'm just telling you, and you know it to be true. The rise, I raise these examples not to deflect blame, but to highlight the broader context in which my errors occurred. I did not willfully submit fake citations. I did not attempt to deceive this court or opposing counsel. I made an honest mistake by failing to audit all citations after using legal tools that now include AI assisted functionality. The legal profession as a whole, including judges, law clerks, and attorneys, is learning to adapt to these powerful but imperfect tools. Again, you got to put in the work. You got to put in the work, and you have to um make sure that what you're writing is correct. I mean, it is what it is. What you're signing is correct. It is what it is. What separates professionals who err from those who mislead is what happens next. In my case, I took immediate steps to investigate the error. I prepared corrections. I appeared before the court. I took responsibility without excuse. I have also I have since completed multiple CLEs focused on AI ethics, legal technology, and solo practitioner compliance, all in an effort to ensure this never happens again. In the broader context, I respectfully ask the court for grace. The use of AI tools is reshaping our profession in real time, and no one, judge or attorney, is immune to the risk of citation error. I have done everything in my power to remediate this mistake, educate myself, and protect the integrity of my practice. I ask only for the opportunity to continue the work without crushing weight of financial penalty that could cripple my ability to serve the public. Conclusion. For the foregoing reasons, I respectfully request that the courts deny plaintiff's petition for attorney fees in its entirety. Alternatively, suppose the court deems some sanctions appropriate. In that case, I ask that it adopt a proportional, non monetary remedy in line with how courts across the country have treated similar situations, including involving AI assisted legal drafting errors. A sanction focused on education, transparency, and accountability will serve justice far more effectively than financial penalties that would cripple a solo practitioner engaged in extensive pro bono work. And it is signed by on Tyrone Blackburn, and the certificate of service. Because the thing of it is that while this is noble and everything, as I stated before, somebody has to pay for this. Somebody has to pay for his mistakes. And he is asking that he be exempt from paying for his mistakes. And that's why I am a proponent of them having to pay fees. So now, I so TD Jakes is just supposed to absorb this cost and be the one that have to eat the cost because of his errors. Do you all think that's fair? I don't think it's fair. Um, I really don't think it's fair for TD Jakes to have to eat the cost of this. Yes, and he included a letter. He submit, his this is an example of the New Jersey ethics grievance that TD Jakes attorney Dustin Push um, served against, complained against Blackburn in the state of New Jersey. Um, then it asked what type of lawyer, and it says other litigation, defamation, civil conspiracy, you know. But he goes on to state in this complaint to New Jersey, Dustin Poach, um, state what the lawyer did or failed to do, that the facts, da, da, da. Okay. It has come to my attention that Tyrone A. Blackburn, a member of the New Jersey State Bar, has made a misrepresentation of his membership in the DC Bar. He made this misrepresentation in at least two federal filings in the case which I am opposing counsel, Jakes versus Youngblood case number Judge Stickman. Blackburn is the counsel on record, admitted PHV for defendant Youngblood, and I am the counsel on record for admitted PHV for the plaintiff's Jakes. In two separate filings, and they attached, Mr. Blackburn noted on his letterhead that he was a member of the DC Bar. I have checked with the DC Bar and confirmed that he is not and has never been a member of the DC Bar. I was advised by the DC Bar that not only did I have a mandatory obligation to report the issue to the DC Bar, but also to other state bars in which Mr. Blackburn is a member. Therefore, I have submitted this grievance. Please see the attached letter. And he's dated it. And Superior Court in New Jersey may seek publicly regarding the grievances of this filing. And he signed it. And this is the letter from TD Jakes's attorneys to the counsel of the Office of Disciplinary Counsel, District of Columbia Courts of Appeals, regarding his bar licenses. So this letter from Meyer, Watkins, Phillips, and Pulse to the Ethics Committee complaining about Blackburn. It goes on, Dear Office of Disciplinary Counsel, I write to alert the bar pursuant of Rule 8.3A of the fact that attorney Tyrone A. Blackburn, licensed to practice in the state of New York Bar ID 5619416, has made misrepresentations that he is a member of the District of Columbia Bar and therefore licensed to practice law in DC. Mr. Blackburn has made this misrepresentation in at least two filings in the District Court of Western Pennsylvania in the matter of Jakes versus Youngblood. This false this false representation appears in the letterhead of the letters filed addressed to the presiding judge, Judge William S. Stigman IV, both of which were filed on June 4th, 2025. dockets 48 and 49. Mr. Blackburn is counsel for the defendant, Duane Youngblood, in the matter, and I am counsel for the plaintiff. These filings are based on Exhibits 1 and 2 to this letter. Mr. Blackburn's letterhead notes that he is a member of NY, DC, and NJ Bar. However, in his application for admissions to the Western District of Pennsylvania Court earlier in this case, Mr. Blackburn had not listed any DC bar membership or New Jersey for that matter, as required under the court's local rules. My office investigated further and discovered that Mr. Blackburn is not and has never been a member of the District of Columbia Bar. First, my office conducted a search of the DC Bar's membership directory, which yielded no results for Tyrone Blackburn. My office then searched for all members with the last name Blackburn, and the searches likewise did not yield any results for anyone with the first name Tyrone or similar spellings. Lastly, out of abundance of caution and at my direction, a member of my firm's staff contacted the DC Bar Membership Services Department, which likewise confirmed that no one by the name of Tyrone Blackburn has ever been a member of the DC Bar. It is my understanding that Mr. Blackburn's false representation about being admitted to the DC Bar may violate any or all of DC's App Rule 49, unauthorized practice of law, and the DC Professional Rules of Conduct 4.1 and 8.4c. I respectfully submit this complaint as required of me under Rule 8.3. I certify that I have personal knowledge of these statements and that they are true and correct to the best of my knowledge. If you have any questions, please do not hesitate to contact me. Signed, Mr. Pulse. They're not playing with Tyrone Blackburn, and they included a copy of his filing to Judge Stigman. As you can see, he states that he's a member of DC, New York, DC, and New Jersey Bar on his letterhead, and this was dated June 4th to the court. And you know, we go through some other stuff. So we're not going to go through all of this. I just wanted to um show you this. So I'm waiting for the judge to make his ruling. I hope he make a swift decision because I'm ready to get back to the case of TD Jakes versus Duane Youngblood. But Blackburn has been a bump, not even a bump, a mountain in the road that slowed this case down significantly. I do not believe, excuse me, that TD Jakes is going to let up on his cases, excuse me, his case against Youngblood. And I think that he is definitely on the prowl to name the 10 John Does. Now, I think you all tell me, um, if Blackburn was smart, would he flip? I mean, there's certain things he can flip, but he can't disclose because he is, attorney-client privilege. Oh, y'all like my earrings? These are my SAVEDNews earrings. I had them custom made. If you like a pair, let me know. One of my favorite um, customizer here in where I live, Ear Candy and More by Urasami. So I don't know whether you all can see this. Yeah, do personal earrings and everything. So they're absolutely gorgeous. But anyway, back to the subject at hand. um, it is my opinion that TD Jakes is going full steam ahead, and he is not at any juncture going to slow down this roll. Um, Even if Blackburn turns and flips on them and tell all that he knows, there's only so much certain things he can tell because of attorney-client privilege. So, not unless something happened after he was fired by Duane Youngblood. Either way, I want this to end. It's a lot of reading. It's a lot of time that we have spent working on this case, and I want to get back to the original case. So, anyway, everybody, let me know what you think in the comments. Do you think that um, it would be fair for TD Jakes to eat the cost of Tyrone Blackburn's errors? Do you think that Tyrone Blackburn should pay the cost and other costs? Now, if the judge wanted to waive court costs, then unfortunately, as taxpayers, even though I'm not in that state, but as taxpayers, this is federal, we would have to eat that cost. But as a private citizen, I don't think that um, TD Jakes deserved to have to eat the cost of the litigation that was brought forth unnecessarily due to um, Tyrone Blackburn's willful disregard to thoroughly vet his motions and his filings to the court. But anyway, everybody, tell me what you think. Like, share, and subscribe. I appreciate you. You have a very blessed day. Bye.
I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear, for every tear he's ever near. Choirs rise on Sunday morn, his love we adore. Each melody a testimony, hearts reborn. In every verse a whispered prayer beyond compare, to lift the hearts of those in dark despair. We testify with